Respected jurist championing constitutional morality, equality before law, and transformative justice philosophy, none other than Honorable Justice B.R. Gawai. His Lordship entered the bar in the year 1985, practiced in Bombay High Court and Nagpur Bench, served as additional judge of Bombay High Court till 2003, and became a permanent judge in the year 2005. Lordship was elevated to the Supreme Court of India in the year 2019, and in the year 2025, 14th of May, His Lordship became the 52nd Chief Justice of India, and one of his major contributions as part of the Constitution Bench, he upheld the abrogation of the Article 370 of the Constitution, thereby reaffirming the primacy of constitutional sovereignty in the Indian federal structure. Honorable Lordship is widely respected for his commitment to constitutional values. This is with deep respect and gratitude that we now welcome Honorable Justice B.R. Gawai, former Chief Justice of India, to present his address. Please welcome sir with a thunderous applause.
Shri Amit Yadav, the Secretary of Social Justice and Empowerment, the senior officers of the Social Justice Department present here, the Member Secretary of the Dr. Ambedkar Foundation, the Director of the Foundation, the Vice Chancellors of the universities present here, the chairpersons of Dr. Ambedkar Chair in various universities, the faculty members present here, there are some lawyers also, and above all, the students. First of all, I extend warm greetings to all of you on the occasion of the 76th Constitution Day. We have today completed 75 years of, we are in fact completing the Amrit Mahotsav of the Constitution of India, which began on 26th of November 2024. I had a privilege of addressing from this very auditorium on the occasion of Dr. Ambedkar's birth anniversary on 14th of April 2024. And I'm really thankful to the organizers, grateful to them for giving me an opportunity to be with you on the occasion of completion of the Amrit Mahotsav of the Constitution Day. As a matter of fact, Mr. Patil was the director in the last year. He had requested me to be here on the 26th of November 2024 for inauguration of the year-long celebrations. But however, since it was a full working day, though I desired I could not come, but I'm really happy that I can make it today. As all of us know, the Constitution is the most precious document for all of us. For persons professing various religions, they might be having various religious texts which are very biased to them. The Constitution of India is a document which is most important to every citizen of India. And therefore, when we celebrate the completion of 76 years of the Indian Constitution, we must pay our tribute to the framers of the Constitution and to the members of the Constituent Assembly who, with their great dedication, devotion, spread over more than 2 years, have given us this most important document. The vision of the founders of the Constitution could be seen from the very preamble which oath we have taken in the beginning of this function. As all of us know now, it began in Maharashtra about 20-25 years ago. One senior officer of the government of Maharashtra, Mr. E.Z. Khobrakade, he has made it mandatory that the preamble should be read in all the schools in Maharashtra. and subsequently we now see that the movement has grown towards throughout the country. All of us know that the Constitution stands on the four strong pillars of equality, liberty, justice, and fraternity. But equality, not only political equality, but equality of social and economic matters also. And therefore, when we reflect upon the journey of last 76 years, I'm really happy that you have chosen the subject for today's conference as the living Constitution, 75 years of democracy, dignity, and development. When the Article 368 was discussed in the Constitutional Assembly, Dr. Ambedkar was criticized on both sides. One side said that the provisions in the Constitution for amendment are too rigid. The amendment could be carried out in most of the matters, by the simple majority of both the houses. On the other hand, he was criticized that the powers of the amendment are too rigid, because various provisions of the Constitution could be amended only if there was two-thirds majority of the members present in the House and ratified by half of the states. He rebutted both the criticisms, and he said that the provisions in the Constitution for amendment of the Constitution have to be there, because we do not know what would be the socio-economic challenges that the next generations would face. And he said that unless we give a power to the future generations to adapt the Constitution insofar as the changing needs are concerned, we will be binding them to a very rigid document. But he said that at the same time, there are certain provisions in the Constitution which cannot be amended easily, like the separation of powers of 3 wings, the independence of judiciary, the federal structure of the Constitution, and so on. And as students of law, all of us have read and reread his speeches in the Constitutional Assembly, and particularly the one on the 25th of November 1949, that is a day prior to adoption of the Constitution. And you would know from these speeches as well as the speech of 4th of November 1948 as to what was the vision of the Constitution framers. Dr. Ambedkar always believed that the Constitution is a living document, it's an organic document, it's a developing document, and it cannot be static. And we could notice that how visionary the framers of the Constitution were. Within 1 year of the Constitution being framed, the necessity was found to amend the Constitution on various factors. One of them was that in one case, the right to freedom was so extensively interpreted that a person was free to speak anything except waging a war against a state. And therefore we find that in 1951, the amendment, the bill which was presented and signed by none else than President Prime Minister Pandit Jawaharlal Nehru. Various reasonable restrictions were provided under Article 19, insofar as the freedom of speech is concerned. The another factor was that in state of Madras that time, the government of Madras had provided a government order by which a reservation was provided for scheduled caste and scheduled tribe. However, the High Court set it aside on the ground that it was violative of the equality clause of Article 14, and the same was challenged before the Supreme Court, and the Supreme Court in the celebrated case of Champarkaran Dorairaji versus State of Tamil Nadu upheld the judgment of the Supreme Court. But as all of us know that our Constitution was wedded to the idea of social and economic justice. And therefore, in 1951, we find an amendment to Article 15, which enables the state to make special provisions for scheduled castes, scheduled tribes, and other backward classes. The third one was that in order to promote the idea of economic justice, between 1946 to 1949, various agrarian enactments were enacted by the state legislatures. Some of the high courts held such enactments to be violative of the fundamental rights, because by that then the right to property was also a fundamental right. It was held that the Sealing Acts or the Tenancy Acts encroach upon the property to right of the citizens, while the other high courts protected them to be in consonance with the ideal of social and economic justice. And therefore, we find that this gave an amendment to the Constitution in 1951 itself, wherein the enactments which were enacted by the legislatures in furtherance of the agricultural reforms, the abolition of the zamindari systems, and also the provision of the 9th schedule, which provided that various enactments which were made in furtherance of the promise of social and economic justice would not be tinkered with. We also found by the said amendment, Article 31A and 31B was also inserted in the Constitution to protect the measures taken for the agrarian reforms. We have found that in the last 75 years, the Constitution has been amended from time to time. The amending powers of the Constitution were first came to be challenged in the case of Shankari Prasad. The Supreme Court in the Constitution bench unanimously held that the Parliament has the unlimited powers to amend the Constitution. Thereafter comes the judgment of Sajjan. In Sajjan itself, the seats of the dissent were wrote. Though the majority upheld the view of Shankari Prasad, there were two dissenting judgments. Justice Hidayatullah, writing for himself, he said that I would require stronger reasons to hold that the Parliament's power to amend the Constitution are unlimited, and it also has the power to amend the fundamental rights. Justice Budolkar, he wrote that no doubt that the Parliament has wide powers to amend the Constitution, but could it have also the power to take away the basic features of the Constitution? According to him, if the basic features of the Constitution were amended, then it will be almost rewriting the Constitution, which will not be permissible in the amending powers. And therefore, we find that the doctrine of basic structure, which has been evolved subsequently, finds its seats in the judgment of Justice Budolkar in Sajjan Singh. Thereafter comes the judgment of Golaknath, I.C. Golaknath. The 9 judges held that the powers of the Parliament to amend the Constitution are restricted, and the Parliament does not have power to amend the Constitution in such a way that it takes away the fundamental rights of the citizens. We therefore find that after that, various amendments were made to the Constitution. The 3 important amendments were by the 24th Amendment made in November 1971, the 26th Amendment made in December 1971, and these amendments, and also the 25th Amendment. All these amendments were carried out basically to do away with the view taken in the case of Golaknath. By amending Article 31 and 368, the amendment was made so as to make the powers of the Parliament absolute insofar as the amendment of the Constitution is concerned. The amendment to Article 13 provided that any law which was enacted in furtherance of the promise of the social and economic justice would not be hit by the provisions of Article 13. All these amendments came to be challenged in the case of Keshavanand Bharati versus the Union. The Supreme Court for the first time and so far for the last time has sat in the combination of 13. And though insofar as amending powers of the Constitution is concerned, the court was virtually split into half versus half. Out of 13, the 6 learned judges took a view that the powers of the Parliament to amend the Constitution are restricted, and the other 6 took a view that the powers of the Parliament to amend the Constitution are unbridled by a majority. The Constitution can, the Parliament can amend the Constitution in the manner it likes. It is only the view of the one judge, Justice H.R. Khanna, which is partly accepted by 6 on one hand and partly accepted by the other hand, that has become now the ratio of Keshavanand Bharati, and which law holds the field today. Justice Khanna held that though the Parliament has unbridled powers to amend the Constitution and even take away the fundamental rights, but it does not have power to amend the Constitution in such a way that it takes away the basic structure of the Constitution. And therefore, Keshavanand Bharati is one of the most important milestones in the development of the constitutional journey of the country. It carved out various basic structures like the separation of powers, the independence of judiciary, the supremacy of the Constitution, and so on. Subsequently, various other judgments amplified the scope of basic structure. Thereafter, the Constitution came to be amended on various occasions, like Article 39A was introduced so as to provide free legal aid and promote justice on the basis of equal opportunity. Article 48A was inserted, creating an obligation of the state to protect and improve the environment and safeguard the forests and wildlife. Article 15(1)A, one of the most important articles which carved out the duties of the citizens, came to be subsequently added. We also find that in order to make democracy more transparent and accountable, by the 56th Second Amendment in 1985, the 10th schedule came to be added. At that time, you must have heard about the IRAMs and GAIRAMs. So the politicians would move from one party to another party again. And to prevent that and to promote the healthy democracy, the Parliament found that a law which will prohibit such the migration from one political party to another political party was necessary, and the 10th schedule came to be inserted to the Constitution. The one more provision was made in that 10th schedule was to give a finality to the provisions of a finality to the decision of the Speaker and Chairman on the defection of on the decision on defection. However, though the amendment was upheld, this court in the case of Theoto Hololam set aside that provision which prevented judicial review by this court, by the Supreme Court. It was held that the powers of judicial review are one of the basic parts of the basic structure, and by an amendment to the Constitution, the same cannot be taken away. Then we have found that for Mahatma Gandhi, the Panchayati Raj was one of the most important aspects, and by the 74th Amendment in 1992, the constitutional status was given to the local self-governments, the municipalities, the Jilla Parishads, the Panchayat Samitis, and also a provision was made for reservations. In the case of Indira Sawhney, the Supreme Court held that the Constitution permitted only reservations in the appointments and reservations in promotion were not permissible. To meet that judgment, the Constitution came to be amended in 1995, and Article 16(4)(a) came to be amended so as to allow reservation in promotion for scheduled castes and scheduled tribes. Then in the case of Mohini Jain and Unni Krishnan, the Supreme Court had held that the right to education was a fundamental right. To give effect to that judgment, in 2002, Article 21(a) came to be amended, which provided free and compulsory education as a fundamental right for children from 6 to 14. We also find now that in pursuance to that, we also have a Right to Education Act, which has been enacted. By an amendment in 2005, by the 93rd Amendment, the Article 15(5) was inserted so as to provide reservation for socially and educationally backward classes in private unaided educational institutions. By one of the recent amendments in 2019, and then third amendment, the reservation has been provided for economically weaker sections, and now by the latest amendment in 2024, a reservation has been provided for 1/3 of seats for women in the Lok Sabha and the state assemblies through Article 330(a) and 332(a). And therefore we find that for over the 75 years, the Parliament, in order to address the socio-economic challenges in the country, have time to time amended the Constitution. At times the Constitutions have been amended to overcome the decisions of the Supreme Court. And therefore, our Parliament has stood by the principle that the Constitution is a living document. I must state that in this journey, the Supreme Court and the High Courts of India have also played a very proactive role. On account of paucity of time, I may not be in a position to detail out all the judgments. But as all of us know that prior to 1973, the view of the Supreme Court was that wherever there is a conflict between the fundamental rights and the directive principles, the fundamental rights were superior. The supremacy of the fundamental rights over the directive principles was the considered view prior to 73. But in Keshavanand Bharati versus Union of India 73 judgment, though we find that the bench was virtually split half-half on the amending powers of the Constitution, it was unanimous insofar as the co-equal importance to be given to the directive principles and fundamental rights. It was held that the directive principles and fundamental rights together and together alone are the conscience of the Constitution. It was held that the fundamental rights are those rights which are primordial rights, basic rights, which are necessary for giving a life of dignity to the citizen of the country. However, the directive principles were an instrument for bringing about social and economic equality in the country. It was held that it was a promise to bring an egalitarian society in the country. And therefore we find that post Keshavanand Bharati, most of the judgments of this court have always upheld the laws which were enacted by the Parliament or by the state legislatures in furtherance of the directive principles. We further find that insofar as affirmative action is concerned, though the initial view of the Supreme Court was that the reservations are by way of an exception to Article 16. It was held that sub-Article 4 was by way of an exception to main Articles 14 and 16. However, the 7 judges case in State of Kerala versus N.M. Thomas overturned that view and held that the sub-article 4 of Article 16 was only saying emphatically what was already implicit in Article 14 and Article 16.1. It was held that Article 14 and 16 give a promise of equality. But equality does not mean giving equal treatment to everyone. It was held that if equal treatment is given to all, it will result in nothing else but widening the gap between them and promoting inequality. And therefore it was held that the special treatment to those who are disadvantaged, those on account of socio-economic reasons were kept away from the mainstream of the society, was implicit in Article 14 and 16, and it was the duty of the court to provide them special measures so that they can march forward and bring and come equally with those who had already marched forward. This was again amplified in Indira Sawhney, the 9 judges case. The court held that court specifically rejected the argument that the reservation was anti-Meritian. The court held that the said argument was totally unsubstantiated. It was also held that for providing reservation, it was not necessary that it has to be done by the legislature. The executive also by an executive instruction could provide for the reservation. And therefore we find that even insofar as affirmative action is concerned, the court, the parliament has acted to be with the promise of being a living document and bringing in changes so as to suit the socio-economic challenges. The learned compare made a reference to the judgment of this court, of the Supreme Court in Maneka Gandhi versus Union of India. We find that hitherto the view was that the fundamental rights which were explicitly mentioned in Part 3 were the only fundamental rights. But the court in Maneka Gandhi said that no, whatever flows from Article 14, whatever flows from the trinity of Article 14, 19 and 21 would emerge as a fundamental right. The case was involving the withholding of a passport of a petitioner who wanted to travel abroad. The court held that to travel abroad was also a fundamental right of a citizen. And we therefore find that post Maneka Gandhi, plethora of rights which are hitherto unknown have been identified by the Supreme Court or the various high courts to be the fundamental rights. We further find that subsequently, in view of various judgments, a series of judgments in the case of MC Mehta versus the Union, and also in the case of T.N. Godavarnam, the Supreme Court, insofar as the environmental aspects are concerned, has evolved various rights to be fundamental rights. And therefore we find that now by the judicial interpretations, we find that right to food, right to shelter, right to live with a human dignity. It was held that right to life does not mean that a person should live like an animal, but the life should be such that a life should be with dignity. Then right to clean air, right to pollution-free environment, right to potable water, right to education, then in the case of Puttaswamy, right to privacy, right against adverse effects of climate change, right against torture insofar as the persons who are behind the bars, rights against arbitrary detention. Have been so many rights which have evolved the years or the decade Supreme Court and the High Court. And therefore we find that, I'm already late because I think your next session is to start at 12. And therefore we find that in the last 75 years, we also have a subject about development. The development of the country is also necessary. At times, there have been instances where the development has been pitted against the environmental concerns. And the court has often taken a view that while the protection of environment, the protection of ecology is necessary, because the resources that we hold are in trust for the future generations, and we cannot leave the future generations with no resources. But at the same time, the development is also for if the country has to progress, if the country has to prosper. And therefore, a proper balance between the ecological concerns and the sustainable development has to be maintained. And therefore, we find that the vision of the Constitution, framers of the Constitution, Dr. Ambedkar always used to say that the Constitution is a weapon of bloodless revolution. According to him, the Constitution was a promise to bring about an egalitarian society, the promise to bring a social and economic justice. For any country, the journey of 75 years for any constitution is not that long. But we find that in the last 76 years, our parliament, our executive, our judiciary has attempted to fulfill the promise of the framers of the Constitution, that the Constitution will be a living document, an organic document. It will be a document which will promote democracy, which will promote the dignity of a citizen, and at the same time march towards the development of the nation. We have, in these 76 years, attained a lot, but there are many more things to be attained. And therefore, on this day, while paying tribute to the framers of the Constitution, let us resolve that all of us will pledge to act in furtherance of the promise of the Constitution makers, the framers of the Constitution, to bring social and economic equality, social and economic justice, along with the political equality and political justice. Thank you very much.
Thank you so much, Your Honor. His Lordship's wonderful address and illustrious address reminds us again of Baba Saheb Bhimrao Ambedkar. बाबा साहेब तो कहा करते थे, तिरंगे के शान वो हमारा संविधान है, हर किसी के हितों की रक्षा हो, ऐसा विधान हो जो सबको जोड़कर रखे, ऐसा ही भारत का संविधान हो. Ladies and gentlemen, we now come to one session which is very beautiful and wonderful and really wondrous. As